Let's call tries. Who will be the better of joint counsel for the welfare of immigrants and Secretary of State for the Home Department?
Good morning. I appear on behalf of the appellant with Mr Piewski and Mr Lowe. The respondent is represented by Ms Kaufman, Mr Burton. The interveners, the RLA by Justin Bates and Mr Lynn. EHRC by Mr Armstrong and Liberty by Mr Westgate, Mr Kirk and Mr Clark. You should have...
People are not underrepresented.
They're not underrepresented, including ourselves. You should have, I hope, a core bundle of documents and a supplementary bundle of documents into which quite a lot of effort has gone to slim down.
Yes, thank you.
So I'm hoping you've got a decent one there, and you've got 4 bundles of authorities, I'm also hoping.
Well, we've got 3 bundles of authorities and a very slender bundle of authorities. Is that right?
Oh, it's not really, no. That's right. Oh, is that right? I better just check you've got the right tabs, otherwise we'll all get in a terrible muddle. I've got tabs 1 to 18 in my first one.
No. 1 to 20.
Right.
Good start, Stuart.
No, 1 to 23. Sorry.
Good start.
23. Right, and then the second one is, I'm assuming 24 to something.
1, 2 of 3 is 24 through to 50.
50, thank you. Volume 3, sorry to pose. Good answer, that's a good check.
76.
It goes up 76.
And then the fourth one has got what in it, then I wonder.
I haven't got a 4th one.
Well, that's good. Because mine only got up to 74, so we're looking good. Perhaps it does go up to 76.
The fourth one I've got is headed CI Nigeria. I suspect it's not meant to be with me.
Well, at least I've got the basic shape, and I'll try and alter the references.
Well, if you could, you've got the same tab numbers as us.
I've got the same tab numbers,
well, if you-
they're just in different volumes, so I'll
Are
try
other
and...
council in the same position, or have you got the same bundles as us? Anyway, refer us please to the tab numbers and we'll get there. Thank
Thank you very much.
Right.
I was going to start with the basic nature of the legislative scheme, if I may.
We're going to start at the beginning, you mean?
I am.
Right.
The legislative chronology and the elements of that scheme are set out in the witness statement of Mr Asmat, if you wanted a summary of the chronology and a summary of those basic elements. His witness statement, if you have it in the bundle still rather than separately, is at page 85 in the supplementary bundle. And I'm going on the page numbering on the right-hand corner. The ones in the middle of the numberings below. So on the right-hand corner, page 85, it starts.
Yes.
And the chronology in the summary that I've just referred to starts at paragraph 15
Yeah.
and runs through to the end of paragraph 28. I'm not going to walk you through it. I'm sure the court will already have seen that and read it, but if you wanted that, it's quite a helpful chronology of all the consultations that happened and then the legislation in 2014, how that was commenced and rolled out in the West Midlands first and then nationally, and then the second act introducing, I think, essentially just the criminal element in 2016. But you've got all the chronology, I hope helpfully collated there, and a summary of the various elements. And as you see from that, there was an extended process with plenty of consultation before and in relation to the codes, which I'll come to. And there was plenty of parliamentary scrutiny, 2 pieces of primary legislation, a number of pieces of secondary legislation passed pursuant to enabling powers in the primary, and then parliamentary scrutiny of the codes, again, which I'll come to. And this was a scheme that was brought into effect in a staggered way, as I've indicated, West Midlands first and then rolled out nationally by virtue of using the commencement.
Was it part of the response to Directive 2002/90?
I think it might have been, in part in response to that.
It clearly goes to the same purpose.
It does, and I'm going to refer to that because you'll see that some of the there's a short comparative bit I'm going to take you to, which shows you the position in other European countries. So to start with the primary is in the first of the authorities bundles, behind tab 3.
Can we put away supplementary bundle?
You can, my lord. I'm sorry, sir. I'm going to refer to Mr. Asmat's statement on a number of occasions, but
Right.
so behind tab 3 of volume 1, you have the Immigration Act 2014 as amended by the 2016 Act. And the basic scheme is to prohibit landlords from letting under residential tenancy agreements to those who are, quote, disqualified from renting as a result of their immigration status. And you find that basic prohibition in section 22, sub 1. And you see the two cases identified as falling within that prohibition in sub 4 and sub 5. I can just ask you to cast an eye down those, in particular 4A and 5A and B.
I mean, in a sense, section 22 is really to enforce section 21, isn't it?
It is, but it is the prohibition.
No, I understand that, but the real...
The real nub of it is the definition of disqualification and how that's defined in 21, which is where I was going to go next.
Yes.
But it seemed logical to start with the prohibition and then show you how the disqualification provides. But my lord is entirely right, it's section 21, but which we can go to next. Just to draw your attention, sorry, just before we do that, in 22, 4 and 5, the distinction, of course, between the situations in 4 and 5 is that 4 is dealing with someone who is indefinitely disqualified, as it were, and 5 is dealing with the limited right, as you see from 5A. But with that background, go to 21, which deals with disqualification, and the person, the prospective tenant, is disqualified if they are not a relevant national, that is section 21(1)A, in other words, if they're not C sub 5, British, EEA or Swiss, and they don't have a right to rent. And they don't have a right to rent, see 21(2), in the circumstances they're set out. In other words, if you require leave to enter or leave to remain, you don't have it, or leave to enter or leave to remain, probably a less common thing, is subject to a condition preventing them from occupying premises, and they don't have permission from the Secretary of State, that permission being dealt with in 21(3). So that's the basic setup in relation to disqualification. Again, this will all be familiar, I'm sure, to my lords. The landlord is liable to a civil penalty of up to £3,000, see section 23, if he enters into a residential tenancy agreement and the tenant is disqualified. That's section 22(4). Sorry, yes, that's the situation in 22(4) that we looked at earlier. Or the tenancy agreement is entered into a person with a limited right to rent and he later becomes disqualified and continues to occupy. That's the second situation in 22 sub 5 that I drew your attention to earlier. But it's a civil penalty was the basic regime until 2016, and then 2016 brought in liability to a criminal penalty. That was the change made in 2016, and that is dealt with under section 33 capital A. If you go forward a few pages in the extract. and again, just to touch on that briefly, he's liable to a criminal penalty if he knows or has reasonable cause to believe that the premises are occupied by a person who is disqualified, and that is subject to the taking by him the defence of taking reasonable steps. See section 33A, sub 6.
So where a disqualified person is expected to live?
Whereas the disqualified,
Where are they expected to live if they can't enter into residential tenancies?
well, my lord, the provisions under ordinary law that govern destitution and matters of that kind will cut in. That's the way the system operates. So there will, in certain circumstances, be obligations on local authorities and so on. And there have been plenty of cases around that.
And the prohibition extends not only to the legal tenant, but also to any adults in occupation of the relevant property, if I understood that correctly. So, from the point of view of inquiries that have to be made, there could be quite a lot of questions about who is actually going to be living at the property.
There may need to be, and that is the subject of, amongst other things, the code, or the codes which deal with and try to describe what reasonable steps would be sufficient. I'll come to the codes in due course. So that's the basic liabilities, civil and criminal, and then there are excuses, so-called under the legislation, and they are dealt with in section 24. Sorry to jump around, but if you go back to section 24. And they're basically divided into excuses pre-grant, where you've got a pre-grant of a residential tenancy agreement contravention, and there the excuse is that the landlord has complied with the prescribed requirements, that's 24 sub 2A, or the agent is responsible for the contravention.
These are excuses in respect of civil liabilities.
Yes. The reasonable excuse defence is already built into the criminal side of things. So compliance with the prescribed requirements is the main one. And then 24(6) deals with a post-grant contravention, in other words, where you've got time limited and it runs out and so on. And that involves notification of the Secretary of State as soon as reasonably practicable, or the agent again being responsible for the contravention. And there is then a system of giving of notices of that civil penalty, objections, appeals, and so on. So it's a decision by the Secretary of State in summary in the first instance, and then an appeal by way of rehearing to the County Court, section 29. And then there are two separate provisions in the primary legislation dealing with codes of practice. And they are, firstly, in relation to the requirement for a general code, section 32. The Secretary of State must issue a code of practice for the purposes of this chapter. And you'll see the factors that it's got to deal with in sub 2. And you'll see the guidance that it can contain, including the matter that I was discussing a minute ago with my Lord Justice Henderson at 3B. And any other matters the Secretary of State considers appropriate at sub C. I'm in 32(3), A, B and C. And you'll see from sub 6 that the code or a revised code may not be issued unless a draft has been laid before Parliament, and it then comes into force in accordance with provision made by order made by the Secretary of State, and I'll take you to that subordinate legislation in a moment. But that's the what I call the general code, providing advice about those matters.
Yeah, I imagine you place a degree of emphasis on subsection 5.
My Lord, I do. I do, but I respectfully submit that both 32 and 33, which I'm going to come to in a moment, are both important.
This is all part of one global scheme, isn't
It's all part of a global scheme. It's got to be kept
and it's
under
mandatory. There must be a code. Not you're empowered to have a code. You must.
Exactly. There's a degree of flexibility about what has to go into it,
But you must have it.
and it must be laid before Parliament.
Right.
So if Parliament doesn't like the draft code, it can holler.
Yeah.
So that's 32, and that's the general code. But there's also a requirement for a specific code, and you see that in section 33. The Secretary of State must issue a code of practice specifying what a landlord or agent should or should not do to ensure that while avoiding liability to pay a penalty under this chapter, the landlord or agent also avoids contravening the Equality Act, so far as that relating to race, race relations Northern Ireland order, time to time review the code and revise and reissue it following review. That's an obligation again that we place some reliance on in 2. And then you see the additional consultation requirements before this code gets promulgated or put before Parliament. Before issuing the code or a revised code, there's an obligation to consult with the Commission for Equality and Human Rights, Equality Commission for Northern Ireland, and such persons representing the interests of landlords and tenants as the Secretary of State considers appropriate. And then after that consultation, there's got to be a publication of the code and consideration of any representations made about the published draft, so a public consultation, a specific consultation therefore with the people identified in 3, public consultation in 4, and then the laying of that draft, after all that has occurred, before Parliament, see sub 5A, and then again it comes into force pursuant to order by the Secretary of State 5B. And then you see the nature of the code. Breach of the code doesn't make a person liable to civil or criminal proceedings, but may be taken into account by a court or tribunal. So if you follow the code and someone claims discrimination against you, for example, you could say, well, I followed the code, that was the requirement, and I invite you, the court, to take it into account. So a pretty comprehensive and a pretty protective, we submit, set of provisions to do with this specific code relating to discrimination. And that we do submit as a matter of some importance. But the basic setup, therefore, of the primary legislation in the Immigration Act 2014, it involves a careful and detailed scheme by Parliament designed to prevent those who don't have a right to live in the UK from obtaining a settled place, no doubt more broadly to encourage compliance with the immigration rules. And the public interest in all of that, which I'll come back to, is, we respectfully submit, clear. But this set of provisions restricting access to that category to benefits and services is not that unusual. It's similar in nature to other measures on the statute book that restrict access, for example, to employment, public benefits and services and so on, to those who are lawfully in the UK. I mentioned the comparative position, just to touch on that very briefly. There appears to be some similar legislation in other EU countries, which bears on the question that my Lord or Justice Hickinbottom put to me earlier on. And you will already have noted that it's a requirement of EU law that states take measures to prevent irregular residence. That was the Directive 2002/90, which I think my Lord was referring to.
And facilitation.
And facilitation, exactly. And that obliges states, Article 1(1)(b), I think is the one my Lord may have had in mind, which obliges states to adopt appropriate sanctions against anyone who, for financial gain, assists a person to reside in breach of immigration laws. And the evidence is that by 2011 at least, a number of European countries were already explicitly prohibiting renting property to migrants in an irregular situation, and other countries were being described as doing so irregularly. Can I just invite you to take up one reference on that, which is the EU Agency for Fundamental Rights report of 2011 in the supplemental bundle at page 114, right-hand corner again. first page is at 114, and the relevant bit, I'm not going to invite you to read it all now, but just to cast an eye down to give you a flavour of it. 118, right-hand column, under National Legal Framework, the heading National Legal Framework, right-hand column on page 118. And you'll see the analysis, the comparative analysis which is then undertaken, and the authors of the report helpfully divide EU countries into various groups. The first one being dealt with in the paragraph that starts just above the first hole punch in that second column on page 118. The second group of countries is then dealt with in the final paragraph on that page. You see in the second group of countries, and then a slightly different legal setup in some of those countries, and some analysis of that. And then I suspect it's in order of decreasing severity of law, if that makes sense. If you go over the page to 119, first column, the third group of countries is dealt with in the final paragraph on the first column of that page, and then there's a table on the facing page 120 which puts into tabular or graphic form that analysis. On the same theme and with a slightly broader feel to it, slightly broader international feel to it, but the same sort of theme. If you go forward in the same bundle to page 384, you will see a document which I'm told is we haven't quite dated it, I'm afraid, but it's a Home Office document prepared by the Assistants of Embassies, I'm told, and we think it's around 2018, but maybe a little earlier. But it's got some analysis of the comparative position, this time extending both to EU countries and also to Australia and the United States, but also detailing the laws that govern access to work, access to healthcare, access to benefit and public funds. So you get a flavour of that as well. So it's a broader comparative piece of research. But the fundamental point about both of these pieces of comparative research is that they demonstrate that the UK is not out of kilter. And you know that sometimes being within kilter or out of kilter, as I know my Lord Justice Henderson will remember from the last case I argued before you, about X in the passport, sometimes being out of kilter or in kilter with other ECHR countries can be quite an important and interesting thing in the analysis under the Strasbourg case law. But that's the comparative research in the documentation for what it's worth. I shouldn't leave put that bundle away if you would, and go back to bundle one of the authorities, because shouldn't leave the primary legislative picture without also showing you the Equality Act 2010, which you saw specifically referred to in the Immigration Act, and that is behind tab 2 of bundle 1. And so it prohibits both direct discrimination by landlords against people because of a person's race, I'll only rent to British people, and it prohibits indirect discrimination, neutral policies leading to groups being less favourably treated. And you see that in sections 13, dealing with direct discrimination, to be very familiar to the court, section 19, dealing with indirect discrimination, and a specific provision dealing with premises in section 33, which is the third of the substantive provisions that you have in the extract. So under 33.1, a person A who has a right to dispose of premises must not discriminate against another B as to the terms on which A offers to dispose, by not disposing of the premises to B, and A's treatment to B in respect of things done in relation to persons seeking premises. So a specific and bespoke provision in the 2010 Act dealing with disposal of premises. You don't have them in the bundle, but again, I'm sure the court will be very familiar with the basic enforcement structure under the 2010 Act, which involves county court jurisdiction to determine civil claims of discrimination brought against the landlord, for example, for breach of section 33. That's section 114 if you want it. And if you want it further, the county court can award damages and other relief if the claim succeeds, including for injury to feelings. That's section 119. So 114 and 119 give you, if you want it, the county court's jurisdiction. So that's the primary legislative picture. The secondary legislative picture, I'm going to take you to one order only in relation to that, and that is behind tab 4 in the same bundle. And this is the immigration residential accommodation prescribed requirements. You'll remember that concept. Prescribed requirement and codes of practice order. You'll remember the provisions in relation to the code that say bring them into force. You'll see the date on which it's laid. You'll see the date on which it then comes into force. That accords to the chronology in Mr. Asmat's statement on the first page. And you see the fact of consultation recorded in the final paragraph of the preamble to the order on that first page. I took you to the primary legislative requirements, setting out those duties, and the record of compliance is there. Its core effects are twofold. The first is that it brings the codes, the general code and the specific code, into force. And you see that from Articles 13. I'm afraid rather unhelpfully these aren't numbered, these pages, but if you flick through to Article 13, that's the general code being brought into force on 1st of December 2014, and facing page Article 14 is the specific code being brought into force. So that's the first of the effects. And the second is to set out what landlords have to obtain by way of documentation to avoid liability under the scheme. And you see that if you go back in the order to Article 3, when we looked at 24.2, a landlord or agent complies with the prescribed requirements if the landlord or agent obtains documents prescribed in Article 4 from an occupier or prospective occupier, and in accordance with Article 5, takes steps to verify, retain, copy or record the contents of a document obtained under Article 4. So if we go to Article 4, it then sets out two lists, List A and List B in the schedule. I'm afraid in my version of the copy the actual words List A and List B didn't feature, but if you go to the end of the substantive articles, the last one of which is Article 14, and you go to the next page, you'll see rather unhelpfully a page headed with the name of the order and then para 1.
Well, we do have List A and List B in our copies.
You have List A and List B, good. So you've got List A and List B, so you see the nature of the documentation that's got to be provided. This is where it's prescribed in Article 4. And then the provisions of Article 5 deal with the steps that need to be taken to check and retain and so on. And you see the sort of steps that are required. Article 5, A, B, C, D, and then the retention obligation in 5E, and F. I'm going to come to the codes in due course, but just to give you a reference at this stage, and if I can invite you to go back to Mr. Asmat's statement in the supplemental bundle. starts at page 85, and I want paragraphs 20 to 25 for present purposes, because it contains a helpful description of this part of the scheme. So it amalgamates this order and the code to which I'm going to take you, setting out the documents in a slightly different form and set of lists, as it were. But this section from paragraphs 20 to 25 contains a helpful summation of what is required by way of documents and checking, and what a landlord can do. There's a reference to, I'll come back to that when we get there, but there's a reference to the landlord checking service in paragraph 25, for example. In relation to list A and list B, he summarised it by reference to the taxonomy and the code at 23. So there are, on the face of the legislation, prescribed and straightforward ways of complying, and easy ways for the landlord to check if needed, with a default position. You saw reference to the landlord checking service in Mr. Asmat's statement, but if you go back to the order itself and you go to paragraph 6, or article 6 of the order, you will see that that landlord checking service, as it were, has built into the legislative regime a default period for response by the state. So if a landlord checks and no response is given within due time, they're effectively deemed to have clearance. So that's the legislative scheme, and then to come, if I may, to the codes, and for that we do need to go back to the supplementary bundle, if you still have that to hand. And I'm going to start with the discrimination code, which is in the supplementary bundle, pages 182A. You've got 182A. So 182 capital A is the code of practice for landlords, and it runs through to 182P as the final page. And the introduction is of some interest to the issues that arise in the case. I don't know whether the court has had a chance to read this document before.
Have you got this in your bundle?
Does the court?
I'm not sure I have.
182A? If
I
not,
have 182 in my bundle.
you don't have?
No.
No.
They've been sent through at a later stage. But
No, it doesn't matter. Can we rectify that? Do the other members of the court have it?
Yes, I have. I've got that. I could quote you.
This is the only A reference.
I've been discriminated against, James.
Well, my lord, I apologise for that.
Probably did come in, and it never got to my desk. I do have current clerking issues.
Almost inevitable
Thank you very much.
mix-ups.
Thank you very much indeed for it.
Could I just invite the court to read, it will take too long to read it to myself, but the court will at least get a flavour, if you cast an eye briefly, if you would, down the introduction, first of all, on 182F to 182G.
Yeah.
Would that be convenient
Yes,
to ask you to read
certainly,
it?
certainly. Yes, many landlords are going to need professional advice, aren't they?
Well, we respectfully submit that they're not going to need professional advice to comply with
Quite,
it.
quite dense, all this. I mean,
Some of it's quite dense, but
to,
that's...
to a lawyer, it's readily
yes,
comprehensible, but a lot of
But
landlords are not lawyers.
but the aim and object of it is to try to make it
I can't understand that.
as simple as can be, and that's
I can see
why,
that.
when we go further into this document, there are there's various further information, and you have the various lists that you do.
It's certainly got big bold headings. And
It's
things
got
like
big
that.
built in, and it's an attempt to try and emphasise not merely
Yeah.
that they've got to comply with the anti-discrimination provisions in the primary legislation that currently exist, and they've got to comply with the provisions of our legislation, if I can call the Immigration Act that, but that there are ways in which they can check if they're uncertain. There are relatively simple checks that they need to perform, and relatively simple and specified categories of documents that they need to call for in the various different situations.
Certainly the box format is quite a convenient way of presentation, because that does draw things. by way of example.
Those are the themes I'm getting from it.
Yeah.
And of course, in any scheme which is of this ilk, you have to grapple with the complexities that we all know underlie the immigration system. So, my Lord, I'm not being unsympathetic to the question, if I can put it that way. We've all seen enough of it. But if you're drawing distinctions in the primary legislation between indefinite leave to remain and a limited right to rent and so on, these engage immigration concepts and different statuses under immigration law. So it's not uncomplicated. But what the secondary legislation, in accordance with the primary, seeks to do is to provide proper guidance about the nature of the steps, amplified by the code, and proper lists of documents, so that the documents are there. If the document is on the list, you know it's good enough. All you've got to do is do the reasonable checks for authenticity. But it's very difficult to see what more could be done. I mean, normally the mechanisms by which government, in which I include Parliament, provides controls, include, in areas of some potential complexity, the primary legislation, more detail and more specificity in the secondary legislative scheme, that's been done, and then, if necessary, to try to make these sorts of issues even clearer, codes of practice. I mean, it's not an unfamiliar thing. One has it in interception of telecommunications recently. I mean, you've got that basic schema, and you have it here. So,
and of course it's going to involve a degree of inconvenience and getting accustomed to the scheme and all that for landlords. On the other hand, that is a feature of much legislation in the modern world.
it is, and that is...
analogy with money laundering regulations, which are tiresome to comply with, we all know, but they are serving a very important purpose.
GDPR.
Yes, indeed.
But in this case, the enforcement could be done in a much shorter way. I mean, and as I understand the brief notes from other European countries to which you've referred, other countries have done this. You could simply have a criminal offence, that it's a criminal offence for a landlord to let to an irregular migrant. Full stop. What this does, it sets out in some detail how you can avoid here civil penalties. That if you do this, this, this and this, if you look at this document and copy it and whatever...
So the complexities of the scheme are essentially protected.
Well, protective, or at least they give, as it were, guidance. In a sense, practical guidance. I know that the landlords say this is terribly difficult and inconvenient, but it gives practical guidance as how to avoid liability.
It does on the criminal side.
But it does on the
civil side too.
The excuses.
Yes,
Excuses
apply to civil.
It's the excuse section which brings in the prescribed requirements, and the prescribed requirements are obviously detailed.
They are. I was going to make the point that the concern of the legislature, self-evidently, see inter alia section 33 of the Immigration Act, the concern of the legislature is also to protect tenants and to reinforce the existing legal requirements in section 33, 9 and 13 of the Equalities Act 2010. So it serves that dual purpose. So I entirely accept the points my Lord puts to me, but it has that additional legislative thrust. They obviously recognised that there was a risk of landlords doing discriminatory things, and they were determined, if I can put it that way, to avoid that, or to take all reasonable steps that they could to avoid that. So you've read the introduction, including the box at the end ahead of definitions, and then there's the reference to the Equality Act, again in on 182H under how this code of practice should be, how should this code of practice be used. Then a big title, Your Duty Under the Law, on 182I, reinforcing the point I just made about it's unlawful to discriminate in the provision of rented accommodation because of race. And then see the final paragraph of that little section, race discrimination may be either direct or indirect, also prohibitions against race-related harassment and victimisation. And then they describe what direct race discrimination is. Then at 182K, discrimination in letting and subletting of property. That's a reference and a description to section 33 of the 2010 Act, which we've seen. And then section 3 of this document, beginning on 182M. Can I invite you to read 182M and N down to the bottom of page 182N, if you would. Or just cast an eye to get a flavour of it at least.
Yes.
So fair practices, you'll note in particular that second paragraph under fair practices, and then information for tenants, but you get the flavour of it. What this code is doing is to aim both ways. It aims to provide landlords with assistance, but also it aims at prescribing or providing information for tenants, and seeking to ensure, if necessary, through landlords saying to tenants, go online, find out what documents you need and so on, so that tenants can turn up and say, we've got the documents we're required to have under this code, here we are.
Is the code only in the English language?
That I don't know, I'm afraid. Can I check that?
Yeah.
Yes, only in English. Only in English. So that's the discrimination code, the specific code. There is then a general code, and we've got the updated or an updated version of the general code in the same bundle if you go forward to page 249.
Yes.
So you'll see from the heading it's been updated on the 12th of February 2016, and this is obviously broader, but it sets out, amongst other things, details of the documents they can rely upon to satisfy the checks. We see that on page 250 under how this code of practice should be used. And note in particular under that title, just by the second hole punch on page 250, Roman 3, the actions a landlord should undertake to comply with the scheme and establish the statutory excuse against liability for a civil penalty, including the reasonable inquiries a landlord should make to determine who will occupy their accommodation, whether that's the question that Lord Justice Henderson asked, and then details of the documents they can rely upon to perform the checks. That's list A and list B and all of that. So there's then a general description, we can take this more quickly, but there's a general description of who can occupy residential accommodation 252, and description in effect of the primary legislative scheme. That's section 3. Who may be liable for a penalty? Section 4 starts at 258. We don't need to trouble unduly about that. 260, more to the point, how to establish a statutory excuse. And you'll see the 3 steps involved described at the top of the page, 260, and then the initial rent checks under section 5.1 under that title. See 1, 2, 3, 4 under that, and then the steps are then, the steps referred to under that heading, initial right to rent checks, are then expanded upon and described. And then steps 2 to 4 at the bottom of page 261, you see that title at the bottom of 261. The document checking process. Out, and then the title at the bottom of 262, how to avoid discrimination. Again, the emphasis on discrimination, the final title at the bottom of page 262. With a reference to the separate anti-discrimination code that we've already seen in the first full paragraph on 263. And then there is, in effect, a slightly different taxonomy, but the same essential documents set out in section 5.2 on page 263, halfway down the page, describing the nature of the requirements and then grouping them as you there see. And I think it was that formed the basis for Mr. Asmat's statement, the paragraphs I gave you earlier. That's the, so list A, list B, and so on. Then, importantly, perhaps, given that if there's doubt, there is a landlord checking service with the Article 6 default rule in it, which you'll recall, if government doesn't respond quickly enough, in Article 6, page 267, right to rent checks from the Home Office landlord's checking service, referring to that default position in the paragraph that starts just below the second hole punch on 267.
Am I right? It's only in certain rather limited situations where one in fact can have recourse to the landlord checking service. It's not a kind of general helpline.
It isn't a general
It's
helpline.
only if you have, for example, an outstanding application or appeal or something of that.
My Lord, yes, and I think that restriction, if it is such, is provided by the online form, which I think exists in certain circumstances. I'm not sure whether we got that in the bundle or not, but my Lord is right, it isn't a general thing, but the code is there. The description of the actual documents that are good enough is there, and there is that if there's
Is there any evidence as to how much use in practice there has been of the checking service?
I think the only evidence I recall referring to it is that paragraph I referred you to,
What's that?
Mr. Asmat.
Mr. Asmat, okay.
I can't remember whether that did or didn't.
Right?
If there's others, I'm sure others will get it. Yes, I'm reminded by going back to that paragraph, which was 25 in Mr. Asmat's statement on page 94, that although I think the answer I gave my Lord Justice Henderson is right, namely that the landlord's checking service is limited, as it were, that paragraph also refers to a telephone service called the Landlord's Helpline, which I suspect is more general. But there aren't specific details of numbers, I'm afraid. That's the general code. There is then, in this plethora of documents, what's called a short guide, which isn't perhaps as short as might be, but that's in June 2018 that was provided, or promulgated, and that's in 366. 366 of the same bundle. Short guide on right to rent. As we will note, another version of this document has recently been produced, I think in July 2019, and that's at the back of the authorities bundle in tab 73, if you need it. But just to pick up, this is done in question and answer form. Look at 369, just by the second hole punch. What about discrimination? And then a click link and a reference to the discrimination code. And then 373, perhaps on the matters we were discussing a minute ago, by the, just above the second whole point, what are acceptable documents for right to rent checks? List A and list B. And then under that a question, how can a right to rent check from the Home Office be requested? So those are the key code and similar documents, and as I indicated, they are summarised and their effect is summarised in relation in particular to the documents that are satisfactory and provide the landlord with an excuse. They're summarised in Mr. Asmat's statement at paragraphs 21 to 25. But just for completeness and finally on this, I ought to refer you to one other paragraph in that statement, if I may, which is paragraph 56. Because you'll recall that I said the code faced two ways. It was trying to inform landlords and assist tenants as well. And you'll see that in 56 an online tool has been created which will assist prospective tenants with understanding documents that are acceptable and to help them gather the necessary evidence before making a tenancy. So it's not just landlords who are being, in relation to their active efforts to assist in understanding and preparing, but also tenants. So against that backdrop, my lords, may I make 5 points about the legislative scheme. Firstly, it's a scheme enacted in primary legislation with the additional elements of parliamentary scrutiny that I've described, and thus represents Parliament's considered choice as to the means of seeking to ensure both A, that immigration rules are effectively enforced and adhered to, and B, the pre-existing legal prohibition against discrimination is practically supported in this context. Secondly, on its face, that legislative scheme applies and is intended to apply to landlords who rent to those who are disqualified from renting as a result of their immigration status. In other words, those without extant LTE or LTR, leave to enter or leave to remain. And my submission is that there can be no objection to a scheme, we've seen the comparative law on that, but there can be no objection in principle to a scheme applying to prohibit renting to that category of persons. Thirdly, the rules set up in the legislative scheme operate on their face to prohibit and sanction landlords in the range of situations it covers. And so all of those rules apply to prohibit and sanction only in relation to the landlord renting to those characterised by being in current breach of immigration rules. Nothing in those rules or in that legislative scheme strays beyond that into permitting any action or any discrimination based on anything else. So Parliament has not either set up legislation which has the necessary effect of discriminating, directly or indirectly, against a prohibited group, nor has Parliament authorised any discrimination by a landlord against those who do have LTE/LTR. And that's the case.
There's nothing in the legislation which imposes any kind of liability or penalty on the would-be tenant who has no right. It's all the sanctions are all directed at landlords, and only directed at landlords. Yeah.
They are. You're right. Fourth scheme flows from that third point, and the third point is important because it's that group about which discrimination complaint is made, those who do have leave to remain and leave to enter. The fourth feature is that Parliament was evidently sensitive to the possibility that private landlords should avoid discrimination. And again, the two features of note you will already have. First, the legislation leaves untouched the basic statutory protections against discrimination, those contained in the Equalities Act 2010. There's no answer for a landlord to say that they consider it easier or less risky or more economic to discriminate. That couldn't and wouldn't provide any answer. But secondly, and perhaps importantly, given the practicalities, the legislation makes specific, precautionary and detailed provision against that possibility. It's crystal clear. It provides no warrant for discrimination and on the contrary makes active provision to avoid it. Section 33, I should be clear, Section 33 of the Equalities Act you've seen, but Section 33 of the Immigration Act is integral to the scheme. And it acknowledges in terms that the law already protects extensively against discrimination by landlords in the Equalities Act. And nothing in the scheme alters that legal protection. But what Section 33 does is to provide mandatory, legislatively required, practical support for that implementation in the requirement for the code and for all the processes that precede its making. Or the codes up, I should say. So in this case, a primary legislative scheme has been declared incompatible despite not sanctioning, not permitting, and on the contrary, positively seeking to reinforce the existing legal protection against discrimination. And the fifth feature of the scheme is that the primary legislative scheme itself envisages and is supplemented by the sort of structure that you would expect to see where the context is inevitably of some complexity, namely secondary legislation with the detail becoming enhanced as you go down the hierarchical tree, if you will, with the secondary legislative provisions that we've seen and with the practical guidance set out in the codes of practice that we've seen. So I turn from those 5 points about the basic legislative scheme to the basis of the claim and its ramifications. The claim is based on the fact that the scheme prohibits landlords from renting to those without LTE or LTR, and they may sanction them if they do so. There's nothing wrong, we submit, with the prohibition. There's nothing wrong with the sanction. There's nothing wrong in principle with primary legislation supporting immigration rules by rules applicable to private individuals, preventing them from doing things in relation to those in breach of the immigration rules and the system it sets up. So the legislation itself does not treat people differently on prohibited grounds, for example, race. This is not direct discrimination. nor is it a case, which one often has in the social security context, leading to all those cases that have gone to the Supreme Court in recent years about that, nor is it a case in which you have a neutral provision which affects one protected group more than another. In other words, legislative indirect discrimination. Instead, the case that is made is that there is discrimination because the legislation, it is said, may in practice cause an unknown number of private persons, landlords, to rent to British people and not to non-British people who have leave to remain or leave to enter. So this isn't a discrimination claim that targets, as the discriminated group, those who are in breach of the immigration rules. There's no challenge on that basis. This is a challenge that says this scheme has the accidental and unintended effect of discriminating against those who do have LTE or LTR on grounds of race or nationality. And the ramifications of that scheme, of that claim, if right, are, we respectfully submit, serious. There is unlawful discrimination if it's right, even though the scheme on its face, in other words, applying simply to prevent rentals to those without LTE, LTR, there's unlawful discrimination even though the scheme on its face serves an important public interest and is justified and is not discriminatory on its face. And even though the law, reinforced in this very scheme, positively prohibits discrimination by landlords, it would mean that the legal prohibitions on discrimination are effectively to be ignored in the analysis, or at least may in effect be overridden if there is a risk that landlords will discriminate in spite of them. And the reasoning, if that's right, is of potentially broad application and might apply whenever, despite a prohibition, rules impose obligations or prohibitions on private individuals, and those private individuals may, despite being legally precluded from doing so and prohibited from doing so, be tempted to act in a discriminatory way. So that's the basic nature of the claim that is being made. The bold question, it might be thought, however, is what is the correct approach in principle when a challenge is made to a legislative scheme in primary legislation of this kind? And I wanted to show you three Supreme Court cases on that topic. Put the supplemental bundle away, if you would. And if you could take up bundle 2 of the authorities, tab 30.
Can we put bundle 1 of the authorities away?
You can as well, my lord, I'm sorry. This is the Christian Institute case and the Lord Advocate, and the members of the court may well have had a chance to look at this case beforehand. But so tab 30, Christian Institute.
Yes.
And if you, I would invite you to cast an eye down the head note, but the head note is extremely long and rather complicated, and I suspect we don't really need it for present purposes, but you get a flavour of what the case was about from paragraph 1 of the, effectively the judgment of the court, with Baroness Hale, Lord Reed and Lord Hodge, with whom Lord Wilson and Hughes agreed. So a 5-person court, so a judgment of the court. And if you just cast a brief eye down paragraph 1, you'll get the flavour of the scheme that they were considering. And the key bit for the purpose of the Christian Institute case concerned sharing of information, as you see from about 2/3 of the way down paragraph 1 and towards the end of that paragraph. So there's an extensive analysis of and description of the relevant legislative scheme, and then the human rights challenge, which is the one that will provide the principles of interest to us. The analysis of the human rights challenge starts at paragraph 67 on page 53 of the report. And you'll see from, they recite Article 8, which is well known.
So a direct infringement of Article 8 was asserted.
It was, and also you'll see the two types of challenge that were being mounted in para 68.
Yeah.
Do you see that? The broader and the narrower challenge. And the narrower challenge focuses on the provisions in sections 26 and 27 for the sharing of information about the child. So they effectively said it was a breach of Article 8 to have this named person looking out for the welfare of children in all cases, and then there was controversy around the sharing of information with that person.
Right.
That was the scheme, and they basically held, in accordance with law, that the legislative provisions were effectively so incomprehensible as to be not in accordance with law, too broadly framed. But the interest from our perspective, it lies when they come to consider the proportionality challenge, and that begins under paragraph 86. And the reason I'm going to this case is because it shows you what the approach is, and should be in principle, when what is being challenged is a legislative scheme which ex facie is not problematic, but might give rise to the risk of incompatibility in individual cases. I mean, here we're a fortiori that on one view because it's mere accidental and unintended effects. But if you look at 87, in assessing proportionality, they say it's necessary to distinguish between the 2014 Act itself and its operation in individual cases. And then they describe the Act and the provisions. And then the key paragraph is the one that I hope will be sidelined in your report. This court has explained that an ab ante challenge to the validity of legislation on the basis of lack of proportionality faces a high hurdle. If a legislative provision is capable of being operated in a manner which is compatible with convention rights, in that it will not give rise to an unjustified interference with Article 8 rights in all or almost all cases, the legislation itself will not be incompatible with the convention. So in order to attack the legislation itself as legislation, you have to demonstrate, if you're the claimant, that it will lead to incompatibility in all or almost all cases. See, for that purpose, BB, which I'm going to go to in a moment. The proportionality in this case, they say, does not surmount that hurdle. Nevertheless, it can readily be seen that in practice and so on, the sharing between information are likely to give rise to disproportionate interference with Article 8 rights unless the information holder carries out a scrupulous and informed assessment. So that's individual cases. So you can't have a go at the legislation because it doesn't meet that test of, in effect, leading to incompatibility in all.
Your primary position is stronger than that, because you would say, in terms of Article 8, in no case will there be an interference by reference to Article 8. I know we have Ms. Covenant's respondent's notice, but that would in fact be your primary position.
Yeah.
I appreciate you're citing this case for a slightly different purpose at the moment.
Well, I'm going to this case because even if one could bring in, as it were, accidental effects,
Yes. Still, that's not enough, you'd say.
Exactly.
In fact, your primary position is stronger than that.
Exactly. That's why I
Subject to respondent's
my lord is right. That's why I described it as our case being a fortiori.
Yes.
But that's the principle, and you see that in operation when the analysis.
Lord Newberger has something to say this in one of the cases about him saying we have a bright line rule. There will sometimes be hard consequences in some cases, but that does not affect.
Yes, it's not quite the same principle. This
justification. He's talking in terms of justification, I think.
He is. And Bright Line plays in there. This principle goes rather more directly to the question, how can you have a crack at legislation?
I follow. Yeah.
And you'll remember there are all those other cases where policies are in play, detention action and those sorts of cases in which a slightly different rule applies in relation to policy. But here we're dealing with a challenge to the legislative scheme. What's the test? And here the legislative scheme has effectively been not struck down under the HRA, but section forward under the HRA. So the challenge is to the legislation.
But to turn this paragraph round, does it mean that legislation can only be struck down or found to be incompatible if it's incapable of being operated, if it's incapable of being operated in a manner which is compatible with the convention in most of the cases?
That's putting the same point in a slightly different way.
It's simply turning it round.
Like civil partnerships.
Yeah.
Yeah.
But that's the test.
That's the test.
Yeah, that's how you judge whether the legislation itself is the problem, and it echoes into a case I'm going to come to called Roberts, which is as much about state responsibility as anything else. But it's the same sort of principle I'm going to come to. But my Lord Justice Hickinbottom puts the obverse of the point of the way in which it's put here.
Yes.
But it's the same essential theme, and you see that it's about capability. You see that when the analysis works through. If you look at paragraph 94. Fourth question, that's the classic fourth Quiller question of proportionality, whether the impact of the rights infringement may be disproportionate to the likely benefit of the impugned measure.
It's still a very difficult decision.
This one is difficult. Quiller, yeah.
We won't go there, but
I don't think we need to.
It's a very difficult decision.
It isn't, but that basic proportionality taxonomy is not just Quiller. There's no escaping from that now.
And also this means, particularly if you put it the reverse way, which I've tried to do, you have to focus on the primary legislation.
You do.
So if things aren't quite right in subsidiary legislation or other parts of the scheme,
Exactly.
that's not enough.
And the solution is to sort those in individual cases. But that question, when can you get at the legislation on human rights grounds?
I'm sorry to interrupt.
Yeah.
To look at individual cases, or obviously to change the subsidiary legislation or whatever it is.
Wherever the primary fault may lie.
Yes,
And
but not the primary legislation.
Exactly.
Yeah.
Exactly. And I was going to say, you see that capacity idea, that capability idea working its way through into the analysis. I was in para 94, second sentence now. This requires consideration of the operation of part 4 in particular cases, since it cannot be said that its operation will necessarily give rise to disproportionate interferences in all cases. So that's exactly the same principle as the one that they've described in paragraph 88. And if you go forward again into paragraph 96, where they're dealing with the information sharing provisions, you'll remember that. And what they say about those doesn't terribly matter, but to pick it up halfway through paragraph 96, in our view, given this role of the information holder, it cannot be said that the operation of the information sharing duties and powers in relation to any of the named person's functions will necessarily, that word again, amount to a disproportionate interference with Article 8 rights. But for the
But it's the last bit of that last sentence. Yeah. Is the Act capable of being operated in a manner which is compatible with, and you would say, yes, it's designed to.
Exactly.
That's what you'd say.
That's exactly right. But at the moment I'm simply on establishing the nature of the test. And the nature of the test you see from para 88, and you see it reflected in paras 94 and 96 with their references to necessarily and capable.
Yeah.
So that is Christian Institute. And you remember that in 88, the citation which they relied upon for their statement of principle in 88 was BB. And BB is in same bundle at tab 26. And just go there briefly. And so BB was, Christian Institute was an Article 8 simpliciter case. BB was, as you may recall, 8 and 14, and it was about English language. I can't remember whether my lord in the chair was in the Court of Appeal in that case. No, perhaps you weren't. Anyway, it was about the English language testing as a precondition to coming to the country. That was effectively what it was about. And there was an immigration rule that was being challenged. And you see the court's analysis. Can I just invite you to read the first and second paragraphs, and the bit I particularly want is the final couple of sentences in paragraph 2, but one will give you the flavour and leads into 2. So it was a challenge to the immigration rule. And you see the reasoning in paragraph 2. They say the rule itself is an unjustifiable interference and discriminatory. They've set themselves a difficult task, I'm picking it up on the bottom of page 5059, may well be possible to show that the application of the rule in an individual case is incompatible with the convention rights of a British partner. It's happened in the case of Quila and so on. Much harder to show that the rule itself is inevitably unlawful, whether under the Human Rights Act or common law. This was possible in the case of yet another marriage rule in Bailly. It's not surprising, therefore, that Mr. Justice Beatson concluded that the fact that it might be possible to argue that the operation of a rule was a disproportionate interference with an individual's Article 8 rights did not render the rule itself disproportionate. So again, that distinction between individual cases and the consequence of legislation and the legislation itself. The paragraphs that were cited by the court in Christian Institute, as you will recall, were first of all paragraph 60 from the judgment of Baroness Hale. I would not strike down the rule and declare it invalid. It will not be an unjustified interference with Article 8 rights in all cases. Paragraph 60, first sentence. It is capable of being operated in a manner which is compatible with convention rights. And then there's a dispute about what form of remedy should be granted, which we don't need to get sucked into. But those first 2 sentences of 60 feed directly into and are supported by the full court in Christian Institute, and they are to exactly the same effect. Lord Hodge, Paris 69 was the paragraph that was, I think, relied upon in Christian Institute. That's on page 5078. For the reasons I discussed below, I think there may be a number of cases in which the operation of the rule, in terms of the current guidance, will not strike a fair balance. But there may also be many cases in which it will. The court would not be entitled to strike down the rule unless satisfied that it was incapable of being operated in a proportionate way, and so was inherently unjustified in all or nearly all cases. And they cite the Court of Appeal in MM Lebanon.
Yes?
I wanted to take you to, well, perhaps I'll take you to it under state responsibility, but the conclusions, therefore, in relation to those 2 cases, Supreme Court cases we submit, are that their reasoning is of general application whenever it is said that a scheme which is ex facie unobjectionable creates nevertheless risks in its operation of incompatibility. And bear in mind that in Christian Institute it was primary legislation, and in BB it was in effect secondary. It was an immigration rule, but the same principle applies, and it's a principle of general application. It goes to help the court determine when the actual rule itself, or when the primary legislation itself, is incompatible, as compared to it just leading to some risk of incompatibility in its operation. And the principled approach that is set out in those cases requires it to be asked whether the scheme is capable of being operated in a way that is not incompatible. And in order to overcome that, someone would have to establish that it would operate incompatibly in almost all cases.
But I think you would go further than that. I think you would say the scheme is designed to operate in a way which is compliant.
My lord, that was the last submission I was about to make. Exactly so. The present context is then, if anything, a fortiori as a submission, given that here there is legislation set up in that way. We've got extant and continuing prohibition of the very sort of thing which is complained about. I was going to show you one case which is considered Christian Institute, and it's going, I think, to the Court of Appeal. I can't remember which issues, maybe all issues, but it's coming to the Court of Appeal at some point. But it was a recent decision of Mr. Justice Supperstone, and it's in, I think, the same bundle, at tab 48, called Open Rights Group. Again, the context doesn't terribly need to concern you. This was about the immigration exemption under their, and raised all sorts of EU law issues under the GDPR and so on. There was also a challenge under the HRA. And you'll see, I simply draw attention, I don't invite you to do more than note them at this stage. The court there picks up and applies the Christian Institute principle as I've described it. See paragraph 61. I'm afraid I'm helpful, it's not page number. Paragraph 61 is the quote from paragraph 88 that you've seen. And the conclusion at the headline level is in 64, second sentence. The challenge to the validity of the immigration exemption on the basis of lack of proportionality is an ab ante challenge. I agree with the defendants. There's nothing in the evidence to suggest the immigration exemption is being operated in a manner that will give rise to an unjustified interference with AA rights in all or almost all cases.
So, Mr. Justice Substone made the excellent and wise choice to accept your submission.
I thought, rather unusually, he did. He did.
Yes, well, that doesn't really add much, does it?
It doesn't much. The only reason for
respect.
referring to it is because the debate in that case was not really about that principle, which everyone effectively surrounded. It was about whether or not there needed to be a code or guidance to supplement the immigration exemption and to bolster its clarity, and he held not in paras 66 and 67. But here again, that doesn't help anyone on the other side, because we've got the codes, we've got the guidance, we've got all the guidance you could want.
Yes.
So perhaps on the same theme, perhaps on a straying closer to in accordance with law, and perhaps straying into territory involving state responsibility, can I show you the third of the Supreme Court cases I wanted to show you, which is the Roberts case, which was about suspicionless stop and searches, and it's in the same bundle behind tab 28. This time you do and can pick up the basic facts from the head note. If you just read from the beginning of the head note down to just about the letter E on page 210, you'll get the flavour of it.
Yes.
And you'll see the finding reflected accurately, of course, in the head note, holding the first of them. The paragraphs I wanted to show you against that background were, first of all, paragraph 2, And the statement of principle upon which I rely is to be found in the final two sentences in that paragraph. There are many laws which are capable, again that word, of being operated both compatibly and incompatibly depending on the facts of the particular case. The compatibility of the law itself has therefore to be judged in conjunction with the duties of the police to operate in a compatible manner. So that is of some interest. And then in going forward in the judgment, they analyse all the various bits and pieces that surrounded suspicionless searches, and their discussion or their reasoning is shortly set out at paragraphs 41 and following on page 225. And you'll see their essential nature, the essential nature of the reason. This was really principally in accordance with law, which were there sufficient safeguards, but they say any random suspicionless power of stop and search carries with it the risk that it will be used in an arbitrary or discriminatory manner. In individual cases, there are, however, great benefits for the public in such a power, as was pointed out by Lord Newbury and Beggle. And then 42, it cannot too often be stressed that whatever the scope of the power in question must be operated in a lawful manner, not enough simply to look at the content of the power. It has to be read in conjunction with section 6 HRA, makes it unlawful for a police officer to act. It has also to be read in conjunction with the Equality Act 2010, which makes it unlawful for a police officer to discriminate on racial grounds in the exercise of his powers. And again, so perhaps self-evident proposition, that when you're judging the compatibility of a scheme, you don't just focus on the act in question, you focus on any surrounding legislation which bears on its operation. So there it was section 6 HRA and the Equality Act. Here it's the Equality Act and all the protections that it provides.
Does it matter in that case that the police, who were the
Public authorities.
yes,
They were, and that's what brought in section 6 HRA, so we don't have that here because it's private. What we do have is the Equality Act, which binds landlords.
You would say that you're A40 or right here, because in Roberts they're talking about agents of the state, namely the police. Here we're talking
About private.
about private landlords.
We are.
But anyway, you're saying the principle here must have.
The principle here, and the principle that we get from 42 is that you look at all the protections that the state or that the legislative scheme provides in toto before judging its compatibility.
And you say if there were to be cases where someone who is entitled to rent but is wrongly refused by a landlord because he hasn't got a British passport, that person has a remedy in the county court.
Exactly.
So yeah, I mean, whether in the real world as a remedy for these people, I don't know. But you say, but in law they have a remedy.
In law they have a remedy, and so that bolsters the protection. But the Bespoke Act itself contains the various provisions that dissuade the landlord from doing that very thing. So they haven't just left it to the Equality Act. They've introduced a scheme of civil penalties and so on for breaching that act, and they've reinforced all the anti-discrimination provisions. Yeah. And so 47 then is the final one, if I may. Particularly the second sentence and following: no system of safeguards in the world can guarantee that no one will ever act unlawfully or contrary to orders. If they do so act, the individual will have a remedy. The law itself is not to blame for individual shortcomings which it does its best to prevent. It is not incompatible with convention rights. Well, that is absolutely foursquare, we submit, with the reasoning and analysis and the principle established in Christian Institute and Beagle.
Yes.
And so we submit that it's clear that Parliament hasn't authorised any landlord discrimination. On the contrary, discrimination on the ground, if it occurs as a result of a private individual wrongly implementing the legislation in a manner that is discriminatory. And the principle, as we've seen from that domestic case law, is not and cannot be that the state is in some way responsible for any act of discrimination by a private individual merely because it occurs in the context of a scheme existing in the public interest in which duties or prohibitions are imposed on a private individual. And just to address briefly a liberty argument, landlords are not analogous to a state agent. They're not the same as the policeman in Roberts. They are private individuals subject to the duties in the legislative scheme
Yep.
And we see effectively that approach or that principle in operation in the various Strasbourg case law when we come to it. But just to flag it now, if I may, without inviting you to turn up those cases, I just wanted to make a few brief submissions whilst we're on this theme. And this theme in Strasbourg is effectively state responsibility. But here it's the domestic application of the principle in Christian Institute. But the DH case, which is much relied upon, which you'll recall was the one about Roma children in being discriminated against in the school system. That's in Authorities, Bundle 3, tab 63. Again, I don't invite you to turn it up now, but there, as you'll recall, the state was responsible for the inequalities in the education system. It set up and operated the education system. There was discrimination of a systemic kind against Roma children, leading to de facto segregation in a separate system of special schools for those with special educational needs, and an unsuitable testing regime, again, for which the state was responsible. There were, in that case, no laws positively prohibiting the conduct said to have occurred. There was no attempt in the scheme itself to reiterate the legal prohibition and to go further and to seek to bolster its practical effectiveness through a code. There was simply, and at best, rank indifference to a system which was being operated by the state in a blatant...
Obviously here the state is not responsible for letting to tenants in these circumstances, but what might be said is that the state is responsible for the scheme whereby landlords may let to tenants.
My lord, it is, to that extent. But that doesn't, we respectfully submit, engage the principles of state responsibility on that basis. Perhaps I'll come to these cases when I deal with ambit. It may be easier to do it now.
No, come to it in due course.
Yeah.
You'll need to deal with the...
With that and Roma
Roma
rights.
case, the Apples case, won't you?
Roma rights, exactly. Which I will submit, you won't be surprised to hear, was a case of direct discrimination.
Yeah, we'll come on to that. Yeah.
And I was going to turn then against that background. What that we respectfully submit is the short answer to this appeal. The submission I've made to date on Christian Institute and the right test. But only judge made a Section 4 declaration of incompatibility about the primary legislation. And I respectfully submit that it was not open to him to do that unless the evidence established that the scheme was incapable in the Christian Institute, Beebe and Roberts sense of being operated. And no one has suggested that the evidence went anything like that far. There's a great debate about how far the evidence does go, but it doesn't go that far, and that's the complete and short answer of principle to this case. I was going to turn to the actual evidence on discrimination, make some points in relation to that against those who have leave to remain or leave to enter. And the submission that we make is that the evidence does not indicate discrimination caused by the scheme at all. And even if there is some potential for discrimination, it's on no view sufficient to undermine the justification for the scheme.
Are you saying, because the judge made some quite trenchant findings here, are you saying that the appeal court can interfere with those findings?
My lord, I'm saying
evidence?
I'm well aware of the limitations on that, and you are, I know, very well aware of the principles that apply. It has to be established that the judge was wrong, and the appellate court is always cautious about intervening in that way. So I'm going to try and make some short points.
Are you saying the judge's evidential conclusion was outside the range reasonably open to him?
I am.
You are?
I am.
Simply not justified?
I am.
All right. I think the trend of authorities has been, more recently, that it doesn't really matter quite so much as sometimes thought that if it was all done on written evidence, the Court of Appeal was in as good a position as a trial judge. I don't think that really holds sway now in the way it sometimes was thought to a few years ago. And you still have really, in effect, the same, I think you accept this, you have the same burden to show the judge simply was not justified in finding.
Well, I do.
All right.
I'm not seeking to diminish the burden that lies upon me in relation to that, and the trend of the case law has been against, as it were, reinventing the wheel in the appellate court,
Lord Reed in particular has
examining all
He's
the
very
evidence.
keen on this topic and has come back to it several times.
he does.
Remember rightly. And indeed, I mean, the basic test, as put in Henderson and Foxworth, is it has to be a conclusion that no reasonable judge could reach.
Yeah.
Anyway, I mean, it's
I mean, it depends on,
not always an insurmountable one.
Quite.
So,
It's not always an insurmountable one. It does, to some extent, turn on the what inferences can be sensibly drawn from the evidence you have, and the severity of the findings, and the degree of.
right, but again, matters of inference are
Are for the judge.
matters for the trial judge.
They are.
Conducting a review, not a rehearing.
They are,
Again,
my lords.
it's
I'm not seeking to.
Right. So we don't have any fresh law on this point. The question is simply applying the principles I think you accept to the judge's own evaluation. Right?
Exactly. It's got to be shown, for present purposes, that there's discrimination and substantial discrimination. We submit for any case to fly at all. And it also must be shown that the discrimination is caused by the legislative scheme. Especially, perhaps it might be thought, as the claimants themselves say, that discrimination was, as they put it, already commonplace amongst landlords. And that's a burden of real significance, we submit, given that most of the persons, or most of the people with LTE or LTR, will be able to prove their identity under the scheme using a passport or a biometric residence permit with which they'll be issued, or a biometric residence card if they're
Just
EU.
clear on the point, your positions, James. Are you saying that even if the judge's factual conclusions in this respect are sustainable, even so he was wrong in his ultimate conclusion?
Yes,
Yeah, it's not clear that you are saying that.
that's why I say. That's why I said earlier on. It's a complete answer.
Started as you
Because
did.
what you've got to establish is that the legislation is incapable. I'm not going to go back over the principles, but on no view does he do that. There was.
I did understand you today. I just want to be clear that,
Yeah.
but you do in fact say, actually the judge got it wrong on the facts.
I do in fact say that as well, but
Yeah.
my
Equally, as I understand it, you say even if he got it right on the facts, and leaving aside your initial high-level challenge to the legislation, you also say in any event it satisfies the test of justification.
yes, I do.
So you have several routes to a conclusion which
I do. I do. But I started with the principal one, I hope for reasons you'll understand, because once you've got the test clear for establishing, you've got to then look at the evidence and say, well, does it go there? No one, I think, has suggested that.
Or putting it another way, it forensically suited your purpose.
Well, it forensically suited my purpose, but also as a matter of principle, it suits the purpose.
Right.
Because that's the logical answer. You start with the primary legislation. My lord said to me, you're going to start at the beginning when I started, and that's exactly where I did start.
Right, anyway, the evidence of discrimination.
So the evidence of discrimination. Firstly, the inherent logic of the scheme was relied upon. It said that the scheme imposes penalties, so landlords take steps to minimise the risk of penalties. That's A and B, if you will. So C, they will discriminate to the detriment of those who have leave to remain or leave to enter. Presumably, on the basis of the evidence, only the sub-cohort of those with no British passports, by preferring people with British passports. And that is rational behaviour. Economically rational behaviour, I think was the phrase bandied around below. And the full step in that analysis we submit is C. So they will discriminate. And it's a full step because it's subject to a complete legal answer, which is that the scheme does not permit and on the contrary prohibits any such discrimination. There is nothing rational about it. Landlords must, like everyone else, obey the law. And they can't justify doing so by saying, well, as a matter of economic convenience or preference, we choose to discriminate. That's no answer. So we say there's a complete legal answer, but it's also a factual non sequitur, because it doesn't follow that just because a legislative scheme imposes penalties and persons who are subject to those penalties might be tempted to take shortcuts, that they will operate in breach of the law in other respects. It simply doesn't follow as a logical conclusion.
I mean, it's sometimes easy in a case like this to lose sight of the big points, and this really is a very big point. I mean, it's the obligation of any citizen to obey the law.
It is.
And that really, well, that's the beginning and the end of your argument at this point, in a sense.
It is on the inherent logic, because the inherent logic must have built into it, if it's going to work, that landlords are acting in, as it's described, a rational way in disobeying the law. That simply isn't.
And then it leads to the very strange conclusion that legislation can be held invalid despite all the built-in safeguards which it contains to prevent unlawful conduct, just because it is said people will act as economic automata regardless of their legal obligations.
Yeah, exactly. And that's a very strange and unattractive place. So we respectfully submit that the inherent logic operates.
If landlords would say, or even think that they're choosing to discriminate, that may not be in their minds at all. What are in their minds is they just don't want the hassle. But they're not choosing to discriminate.
Well, my lord, they would be. I mean, because the example that you have to posit is of someone with all the guidance in place, someone turning up and saying, I have a document, shows I've got indefinite leave to remain, it's not a British passport, because all the evidence is about British passports versus other documents, it appears, but I've got some other document, it's on this list. I've been to the Home Office online checking service, I've got my documents together, I can tell you it's on this list. And now, or a landlord says, I mean, you have to posit, the irony is, you have to posit a landlord who knows that the scheme exists, because the incentive to act in this way is said to be the existence of the penalties. But that again, to come back to another simple point, that makes the thing impossible. Because if the landlord is operating on the line of least resistance to avoid the penalties for certainty, and the certainty provided by the provision of a British passport, then you can't say, well, he knows about that bit, but he can be excused from looking at any other bit, from examining the code or from seeing whatever other material there is in the legislation. Or you can't assume that he's unaware of the various types of documents that can properly be produced and is unaware of the fact that you can't simply say, well, I'll call for a British passport, because that would be a clear case of discrimination. And you can't, as it were, say, well, here is this landlord who is being motivated by the existence of these penalties to act in an economically convenient way, but by the way, you can ignore all the other guidance and all the strictures and all the prohibitions in the legislation itself.
Well, can we just go to, since we're here talking about a factual matter, can we just go to the judge's judgment? And you can just identify precisely where, as you say, the judge went wrong in a way which is not open to a reasonable trial judge.
Well, my lord, in paragraph 96,
you referred to step C in your argument. I hadn't made a complete note of what you were saying there, but I'm just wondering from which part of the judgment you were intending to have in mind when you said that.
well, it was really, particularly in 96 at lines 5 and 6.
Yes.
It's a short step, he says, to conclude that such discrimination is a result of the scheme when the landlords say so, and when it's logical for them to act for the reasons cogently set out by Mr. Bates on behalf of the RLA. And in paragraph 93 at lines 8 and 9.
So which paragraph?
That was paragraph 96.
I've got that.
And, sorry, 93,
Yeah.
lines 8 and 9. Not only asserted by the landlords, but as a logical consequence of the scheme for the reasons convincingly submitted by the RLA. So the conclusion appears to be that it's logical. That's why I did the inherent logic of the scheme. It's logical for landlords to commit race discrimination.
I found the word logical puzzling.
You find the word logical.
Logical, very puzzling.
Well, my lord.
That's the word he uses. I
It is.
do find that very puzzling.
It is.
And you may say in point of practice that's what's happened, but he says logical is...
Yeah. But that's why I started with the inherent logic.
One would have thought it's illogical.
Well, it's not merely illogical, it's illegal.
And maybe the judge didn't quite mean that. What he said is the practical reality is.
Yes.
Maybe that's what the judge is really trying to say. Is that then there's, I mean, I'm not going to shoot the judge down the choice of one wrong word, but maybe what the judge is trying to say is that the practical reality on the ground is that this scheme is causing landlords.
Well, my lord, I mean, I've tried to read the judgment fairly, and I'm not trying to hang him on a single word. You've got logical in both of those paragraphs. You go back to paragraph 79. He appears later on to be accepting that submission. Look at the second sentence. The rational landlord will seek to avoid the situation, and therefore anything that interrupts prompt pre-letting will be avoided if possible, and so on. And so it's rational to prefer a person with a British passport.
Non-law abiding landlord. That's an interesting concept.
Exactly.
So you say if the judge is wrong in that logical approach, that, as you would submit, opens up entitlement of the Court of Appeal to interfere. So the judge has actually wrongly approached the matter as though it's a matter of logic.
Yeah. Well, that's part of it. That's part of the challenge to it. And
But if the judge's reasoning's forward in that way, I mean, your submission is that then would entitle this court to interfere.
Is it? Yeah.
You thought it otherwise should.
I do, because he does seem to have approached it on the basis that whether it's hidden or overt, and it appears to be more overt than not with the repeated references to rational behaviour and logical, and trying to read the judgment fairly, not to hang him on individual words, he does appear to approach it on the basis that the discrimination which he says exists and is demonstrated by the mystery shopping and all of that, to which I'll come in a moment, is the result of the scheme, is caused by the scheme. And that it's caused by the scheme because it's entirely understandable, to use a neutral word, that landlords will discriminate in that way.
I mean, this seems to come out of, at least in part, or this seems to be reflected in the skeleton argument for the landlords before us, where rhetorical questions are asked. For example, why would a rational landlord willingly expose himself to these risks? So that sort of the rational landlord seems to come in there, and no doubt that was in evidence before the judge, because the landlords intervened there. That seems to be where it's coming from.
It's coming from there.
And that's driven by the concept that the landlords are overwhelmingly driven by financial considerations. For example, not having an empty property.
Yeah.
I'm not quite sure whether rational landlord or logical, I'm not sure any of these words are the right words, but it's looked at from a financial point of view only, it's understandable.
It is. And what it's trying to do is to pin the discrimination about which complaint is made, which I keep emphasising is discrimination against those with leave to remain. It's trying to pin that discrimination on the legislation. So all of this goes to, in effect, if you will, a causal link between the legislation and the discrimination about which complaint is made, for the purpose of saying it's the legislation what done it, and so you, the court, can declare it incompatible, because there's the link. That's why. And the first answer is the answer of principle from Christian Institute, which is that isn't the right test anyway, for all the reasons I've gone through and I won't repeat.
I suppose it might be said that a few successful proceedings in the county court might concentrate landlords' minds wonderfully.
That's possible. That's possible. But the logic of the scheme...
Just as no doubt a few prosecutions of landlords might concentrate their minds wonderfully going the other way.
Right.
And it really boils down to saying that because the saying that the legislation provides economic incentives to act in a particular way, leaving aside the fact that to do so would be unlawful.
I think it's more complicated.
That rider makes all the difference. If it weren't unlawful, then of course economic incentives would be to do precisely what the RLA says they tends to happen in many cases.
Quite.
But that can't alter the fact that Parliament has now changed the law, and however inconvenient it may be for landlords, it's their duty to obey it.
And this is an attack on the legislation. So my respectful answer to all of those, whatever it's logical or rational, or it's an acceptance of the legislation being the driver for discriminatory behaviour, my answer to all of that goes back to the scheme of the legislation. It doesn't merely not permit that. It's not direct or indirect in any of those senses. It positively sets its face against it for all the reasons that I indicated. And so to say...
It might be said that if, as the judge perhaps thought this was a matter of logic and rationality, his approach would have significant implications for other cases in totally different fields.
Well, for exactly the reason that my Lord has just given.
That's what Justice Henderson's been written.
Exactly so.
Because there's one thing, an Act of Parliament setting the scene whereby people might want to exploit it, that's one thing. You say that causes it, and you get this in the law of tort frequently. The fact that a certain act gives rise to an opportunity for something to happen doesn't mean it's actually caused it.
No. And a fortiori, it might be thought, when the scheme has evidently decided that it is alive to the risk and is taking positive and active steps to try to meet that. So we do submit that without trying to take clever points about precise words used by the judge, there is a fundamental problem.
The judge has got a flawed approach.
Yeah, it's a fundamental flawed approach and problem, which is to say that it is logical, rational, causative, or acceptable, take whichever one you will, to say that a scheme which sets up a system of penalties and so on for good reason, which creates economic incentivization in a particular group of private individuals, can then thereby be said to be itself discriminatory. It just simply doesn't work, I submit. I mean, all of these points I'm coming to are, as it were, drilled down points on the evidence. So that's the big point on inherent logic. So far as the mystery shopping exercise is concerned, our case in relation to that and the judge's findings on that are set out in some detail in writing in our skeleton between paras 28 and 30, skeleton 28 to 30, supplementary skeleton paras 20 and following, and in Mr. Asmat's statement between paragraphs 32 and 37. And just to draw out 4 short points in relation to that, if I may, without inviting you to go back and reread all of those. There's firstly a documents point. It's necessary, we submit, to have evidence that landlords are acting to discriminate in the face of documents which are demonstrably compliant with the scheme. If you're going to start doing mystery shopping and all of that, you need, as a minimum, to posit a situation in which your comparator on the other side, which appears to be British passport, is actually being compared with someone who turns up with a document and is able to say, here I am, here's the document, it's in list A, or it's in the 2 documents in list B, or whatever. That's, I comply with the requirement, and then there is a difference of behaviour. And the evidence doesn't go close to that. There isn't even, and there wasn't even, detail in that mystery shopping analysis of the documentation offered by the comparator with the British passport. And there's a real question about that. So, for example, and just to give you a reference without inviting you to turn it up, paragraph 7 of Mr. Patel's statement, supplemental bundle, page 61, shows that the British tenancy applicant explicitly offers a British passport, whereas a person who has ILR refers only to an unidentified, unspecific Home Office document. So the comparator is set up in an unbalanced way, is really the complaint. it's not a comparison between someone who says, here I am, I've got a British passport, as against someone who says, here I am, I've got a biometric residence card, and by the way, it complies with all the various provisions of
Is that discussion evidence of people who have the European Union passport?
Exactly.
Is there a comparison? Is it always British?
No, it's always British.
Always focused on British passports.
Yes.
So if someone has a French passport or an Italian passport, is there any analysis of that?
No, I don't think so. I think it's all British.
All British.
All British versus some other unspecified documents.
I mean, if it were, for example, a Lithuanian passport or one of the more recent additions to the member states, one can imagine a landlord on the street might find that just as puzzling as many other forms of document.
But again, I agree, that goes in the same way to assess how much you can actually draw from these sorts of comparisons. And it's a difficult thing. And to give you the reference back into the judgment, the judge recorded, my learned friend Mr. Piewski was presenting the case below for the Home Office, making that complaint, paragraph 85 of the judgment. And it was also taken for good measure in the High Court skeleton, paragraph 43, and in Mr. Asmat's statement, but then doesn't address it, doesn't answer it. And so that was paragraph 7 of Mr. Patel's statement, and the Ramesh example didn't even identify what document he could offer, unlike the Harinder example. So there's no fair comparison between the Brit and the non-Brit, if I can put it that way. We submit, and the judge just doesn't grapple with that. But that is an essential feature. If you're going to say you're discriminating against people on grounds as serious as nationality and British versus non-British, the comparison's got to be set up in a fair and sensible way. That's the first point. The second point is a baseline point, if you will. There isn't any comparison in the evidence the claimants relied upon, the judge considered, between scheme and non-scheme.
There was no control group.
No, exactly. I mean, you saw the Home Office one that dealt with ethnicity only, so it was limited in that respect, but there was no comparison at all between scheme and non-scheme. And you can't simply assume that even if there is discrimination, it's caused by the scheme. That would have to be the minimum of that would have to be done. Not enough to prove that there is discrimination, or even that landlords prefer certain types of documents. You need to show that they're discriminating because of the scheme, as a minimum. So you need to compare the situation where the scheme is in operation and where it is not. And indeed, you would also need to take account of other possibilities, such as pre-existing prejudices or faith in British passports or whatever it may be.
So, again, I'm paraphrasing. What you would say is the scheme has not caused discrimination. At most, what it has caused is it has caused landlords to choose to discriminate.
I would say...
And you would say, and that would only render the scheme unlawful if it necessarily caused the landlords. And you say, so far from it necessarily causing them, it's ask them to do the other thing.
Yeah, I do say that, but this is a slightly narrower point that goes to the evidence. And I'm going to the claimant's evidence that says this was discriminatory against non-British people. And the first point I made is about the documents and the unfairness of the comparison. This one is about what I described as no comparison between scheme and non-scheme. My Lord Justice Hickinbottom.
You said that any discrimination that's found may have existed in any event, because there's no control group to compare discrimination with and without the scheme.
And indeed, it's a particular issue, given that, as JCWI themselves noted, it's in supplemental bundle 184 and 194, their case is positive that there was already discrimination in the sector.
Well, there will be. Of course there will.
I've no doubt, across the population as a whole.
Human nature being what it is, of course there will be in some quarters.
But it makes it more important, therefore, to isolate by doing that comparison. The final thing to bear in mind in relation to that is that when it was done by the Home Office in that controlled way, on ethnicity grounds at least, that demonstrated no discrimination.
I was just beginning to wonder, what appears to be a straightforward sentence in the judgment may actually not be straightforward at all. It's the first line of paragraph 93. In my judgment, the evidence when taken together strongly showed not only that landlords discriminate against potential unconstitutional, that's clear enough, but also that they are doing so because of the scheme.
Yeah.
That actually is ambiguous.
Well, my Lord,
In other words, because of.
Sorry.
It is That's ambiguous on one. I'm just looking at it again.
Well, as you know, we respectfully submit that he's wrong in both of those limbs, whether the second one's ambiguous or
I
not.
understand that, but the second limb does seem to me to be ambiguous on reflection. It may be this, as I say, the scheme is the causal background for landlords doing as they are doing, but it doesn't mean to say the scheme has caused it.
No.
I appreciate you challenged the first limb as well. I appreciate that.
Yes. But there may be issues associated with, I mean, if I'm standing back, we cast it perhaps, I mean, Lord Justice Henderson probably had it right. I mean, you cast it in terms of the legislation creating economic incentives or opportunities or whatever it may be. And if you ignore the law, that's fine. Everyone agrees that we're in territory where penalties are imposed and documents are required. Everyone agrees that. So if that's enough to do it, so be it. But my respectful submission is it plainly isn't because of Christian Institute. And what I'm now on is the point that goes to both limbs of the first sentence of para 93, which is whether or not the actual evidence produced by the claimants could remotely and sensibly be said to support those twin and critical findings. And my submission is it couldn't, A, because of what I described as the documents point, the unfair comparison and positing a British passport against unspecified woolly documents that no one was saying, hang on a second, these are perfectly compliant with the scheme. And secondly, because of what I described as the baseline point, or the no comparator point in Lord Justice Hickinbottom's terms, or the scheme versus non-scheme point. And we've raised a third, perhaps third issue to be borne in mind in relation to this. Could be called a specific inference point. The judge draws the inference that there was nationality or ethnicity discrimination between Peter/Harinder, the British with British passports, compared with Ramesh, non-British, non-ethnically British name. But we respectfully submit that that's entirely unclear, and that the difference of action or reaction might just as well have been, and is just as explicable on the basis that Peter and Harinder, the British passport people, had passports, not because they were British. And that's especially so, without getting into the interstices, because Peter did better than Colin, and Harinder did better than Parimal. But we've set out the other specific points on the specific inferences that were drawn in detail in our skeleton at paras 31, and the various other criticisms we mount in our supplemental skeleton, in particular paragraph 22. So we respectfully submit that there are real problems with the specific inference that is being done, the specific analysis that is being done, which is all designed to suggest that there is discrimination on grounds of Britishness or nationality caused by the scheme. And then the fourth point in relation to this is the overall inference point. We submit that there's no justification for jumping from causes a person with indefinite leave to remain to do somewhat worse than a British person in the mystery shopping, even if that is justified. There's no justification for jumping from that conclusion to the inference.
So which paragraph of his judgment are you
Well,
looking at?
I'm really coming to paragraph 60 and 96. 60 and 96.
696, thank you.
And the point is, there's no justification for jumping from the scheme may cause a person with ILR to do somewhat worse than the British person in the mystery shopping exercise, to the inference, which was critical to the ambit finding, that it causes a person with ILR not to be able to get a tenancy at all, or not for a prolonged period. And the height of the evidence in that respect, in JCWI's evidence, if I can just give you the reference in supplemental bundle page 310, was that the person with ILR, so their Ramesh, was more likely to receive a negative response compared to a person with a British passport, Harinder. But what is actually meant by that, when you look at the figures that they themselves deploy in that paragraph, is that he experienced a negative reaction around 55% of the time, whereas the British tenant experienced it around 46% of the time. So it's a much smaller difference than it at first appears. And on their evidence, so therefore the odds of getting a non-negative response are roughly 1 in 2, and that isn't anything like a proper or appropriate or justifiable or sensible basis for inferring not merely that there's that, even on the height of the evidence, slightly finely calibrated difference of reaction, to a place where you say, well, actually, it's going to lead to, I'm prepared to infer that it's going to lead to homelessness, an inability to get a home or a prolonged period.
Yes, I find that very difficult. This is paragraph 60.
It's paragraph 60 and
Because he
96.
said at its the evidence at its highest, the evidence establishes that they will find it harder. In other words, it will take them longer. Fair enough. But then he draws the inference that
There'll be a significant number of people who are homeless.
yes,
That's the point. That even if you take the evidence at its height, it is incapable of supporting that inference. And you'll recall when we, to throw it forward in the analysis, you'll recall that that was a critical finding for the purpose of amended. So those are the 4 short points we make about the mystery shopping exercise and all things associated with that. And I hope I haven't strayed, at least in the way I've put the submissions, beyond the boundaries of what the appellate court can properly do. It is presented on the basis that these were not findings that were properly open. And certainly in relation to this last one, it's simply a matter of the appellate court deciding whether or not, having described the evidence at its height in that way, it is incapable of supporting the inference which the judge then goes on to draw. There were various landlord surveys, one from the Department of Housing and Communities and Local Government, one from the RLA and one from Shelter. Yeah, I'm not going to go back to those. If you want the references to them, the MHCLG one is at supplementary bundle 391 to 392. The RLA one is at supplementary bundle 352 and 402 to 3. And the Shelter one is at supplementary bundle page 285. And they are, I hope I fairly summarise, to the effect of some landlords saying in response to various different questions that they might be less likely to consider letting to someone without a British passport. That's I hope, a fair summary of where they go. And the answers that we give to that are the usual ones. It's unlawful to discriminate. They have to comply with the law. 1. 2, it doesn't come close to the all or almost all test in Christian Institute. Certainly doesn't demonstrate that the legislation is incompatible. And thirdly, and factually, it simply can't be assumed, we submit, that if a tenant produced to one of them, or any of them, documents which did conform to the requirements in List A and List B, and had done what the guidance indicates that both landlords and tenants should do, which is to understand the nature of the scheme, have the documents ready, and then present them. If they presented them as compliant documents under the scheme, that the landlords would say, well, frightfully sorry, you haven't got a British passport. And if they did do that in the face of the scheme, the code would be a matter that the court could be invited to take into account under the legislative scheme. The Secretary of State's evidence, in relation to that, the key, or the evidence concerned is in supplemental bundle, page 211 to 212, and is summarised in Mr. Asmat's statement at paragraph 65 and following. And we do respectfully submit that the evidence that the Secretary of State produced had the real benefit of having a comparison, of comparing the scheme, or comparing before the scheme and after, initial rollout area and the area of England without the scheme. It used an independent body to do the mystery shopping exercise. There was nothing wrong with the questions asked, and the conclusion was no ethnicity discrimination. And again, we do, I'm afraid, submit that the judge did go badly wrong in relation to this bit. He dismissed the relevance of this in paragraph 95 of the judgment for asking the wrong question. So my submission is that the question was the right question as far as ethnicity discrimination was concerned, and ought then to have been balanced with what he found on ethnicity discrimination. But it does indicate a slightly uneasy sense through the judgment that the judgment was unwilling to, or was willing to overlook significant or not grapple with the significant concerns that had been put before him about the evidence presented by the claimants, but was nevertheless driven then to ignore the government's own evidence when it conflicted with them. So to summarise the position on the evidence, if I may, in 4 short propositions. First, we submit that there is nothing in the arguments about the inherent logic of the scheme. It's a non sequitur that it encourages or permits landlords to act in a way which is positively prohibited by law, and in any event landlords are obliged to comply with the law. So there's no rationality, logicality or acceptability in that argument. Secondly, the evidence does not support a proper case of nationality or, on any view, ethnicity discrimination. For all the reasons that I've gone through. Thirdly, there was no cogent evidence at all cited to the judge relating to the consequences for individuals on the ground, even if a minority of landlords did behave in that way, but still less to justify the important leap from the evidence at its height analysed in paragraph 60 to the conclusion that tenants, and a significant number of tenants, will be unable to find somewhere to live.
And you say that was a necessary step to place this within the ambit of Article 8?
I do. But in any event, I submit that it goes to the causation points of the scale.
I understand that, but on...
Yeah, he took it as significant in the ambit argument.
And we will need to get back to the structure of the judge's argument, because that is a very helpful way you're putting it, but we do need to go through the I think, was it Lord Steyn in S who, I think accepting Lord Justice Brooke, set out the 5 stages you follow when you have an Article 14 case.
I'm going to come to Article 14.
But it's quite convenient to follow that 5-stage process.
Yeah.
And ambit, of course, is the first stage.
It is.
But
the next
sorry
topic.
to interrupt, but what you're now saying is that this particular factual point, as you argue it to be, bears directly upon the judge's conclusion on ambit.
It bears directly on the conclusion.
Because that gives him the link.
It bears directly.
Links him to Article 8.
It does, but it also goes to
make sure I've understood your argument.
It also goes to whether or not there's a difference of treatment at all.
No, I understand that, but it
goes to basic discrimination, the very first stage, if you will.
Yeah.
Is there a difference of treatment? If so, is it within the ambit, and is it status, and is it justified, and so on? But the stages of that. But the first stage is to work out whether there's actually a difference of treatment established on the evidence at all.
This is the second stage.
The second stage, whichever. But,
Yes, all right.
but yeah, so it's a slightly
Okay,
different
no,
point.
I'm sorry, I interrupted you. I just want to be clear. And your 4th point?
4th point was, even if on one view it might do so, it comes nowhere close to a basis for holding that the legislative scheme is incompatible, despite its underlying legal prohibition on discrimination.
Right.
Ambit.
Ambit, yes.
Skeleton 38 to 48. Supplementary skeleton 23 to 28 is where we deal with ambit. And there, in particular, the supplementary skeleton, we've dealt at 24 and following in some detail with the respondent's notice contention that there may be direct interferences with Article 8. And our answers are, in very brief summary, no right to a home in principle, fact sensitive whether Article 8 interference.
So you would endorse the judge's reasoning on engagement and direct violation of Article 8. You say judge was right on that.
I would. And that's why we have to get into the complications and difficulties of modalities and all of that, which I'm going to come to. But it isn't, just to sweep some of the ground away, it isn't the classic modality case, if that's the right language to use. In other words, where the state has chosen to provide a right falling within the general scope of the Convention article, even though it's no part of the ECHR requirement to do so. And again, we submit the judge correctly so concluded, paragraph 44 in that respect. So if you provide, I don't know, a social security benefit, you can't provide it to white people and not black people, for example, or men and not women. So the case as put, and the finding against me at paragraph 66 of the judgment, is that the state took action by legislating that, as it's put, so touches or concerns the rights protected by Article 8 in a negative way as to fall within its scope. And I think we're all agreed that there's no example of that, or no comparable example of anything of that kind in the Strasbourg case law. Article 14, as you know, does not require you to have breached a relevant convention right, because otherwise it would be pointless. But equally, it isn't a freestanding equality provision, so you've got to bring it within the ambit. So somewhere betwixt and between those two is the subject of debate and analysis in any particular context. And I know
someone, I think one of the respondents cites Lady Hale on the case is saying the English courts have made heavy weather of the ambit point, which is probably true. But I don't think the English courts should chastise themselves because it all derives from the pea soup nature of some of the judgments emanating from Strasbourg on this, which again, in fairness to them, reflects the rather broad wording of Article 14.
it does, and in fairness to all courts, it is difficult, because once you accept the twin extremities, in other words, you don't have to show a breach, because otherwise that would render it purposeless, and likewise it isn't a freestanding. You've got to design some principles that sit in the middle, and designing those in anything other than a broad sense is difficult.
What's the underlying rationale
Well, I think it's
for ambit? What's the underlying rationale?
I think it's in order to recognise that it is not, unlike some other provisions in some other international conventions, a freestanding anti-discrimination provision. And it is.
It certainly isn't.
It is in the language of Article 14 that it's discrimination in the provision or enjoyment or whatever it is of the rights set forth in this convention. So I think it's that link. It's designing that link. And I should say at the outset that I'm not going to be submitting that the tendency of modern case law, and again it's a debate I had with Lord Justice Henderson recently in the X in the passports case, that the tendency is not to look at ambit and move swiftly on, because it is a pretty broad church, and the case law indicates it can be a pretty broad church.
But Lord Hoffman in the Carson case expressed some anxiety as to the way in which Article 14 was being used admittedly, he was speaking some years ago, and it may be said that things have moved on, but I'm not saying this is, because we're involving a core complaint here. We're talking about ethnicity and nationality. We're not talking about other status here. So, I mean, the claimants have that strong point in their favour on this.
Well, they do in the sense that that's when if you're in Article 14, it's discrimination of that kind.
Absolutely.
And nationality, one needs to be a bit careful to distinguish between the two, because nationality
One does,
is
but nevertheless,
in the context of
nationality.
immigration.
Yeah, but nationality is expressly included in Article 14.
It is. I'm not denying
criteria.
status, but whether one can drag that into an analysis about ambit is a different matter. I mean, what you tend to be doing in relation to ambit is looking at the article which sits underneath. I'm going to take you to Akbar in one moment, which analyses this in some detail. But what you're looking at here, therefore, is Article 8. You're not looking at Article 14, so it's a slightly strange species of analysis to say, I looked and say, if I was in Article 14, this would be a kind of discrimination which is tolerably serious. Ethnicity, certainly. Nationality and immigration is rather different. But what you're focusing on for the purpose of ambit is whether or not you're close enough to an Article 8 right.
Well, it may not be said that you are close enough. Looking at it very broadly, and after all, that is what tends to happen in these cases. Because we all know Article 8 is involved with respect for the home. And in order to have a home, you have to have somewhere to live. And what a tenant is trying to do is to find somewhere to live where a home can be established. And in that sense, it's predictably involving Article 8.
Well,
Even though, of course, we also have the jurisprudence saying that Article 8 does not guarantee a right to a home. So that's where it gets difficult.
exactly. Well, I mean, that's the counterbalance. The counterbalance is Petrovich. So I respectfully submit that those two balance each other out. And the ultimate submission is going to be that you look to determine in a case like this, and one can get sucked in forever to the different types of modality, positive and negative analysis and so on. But ultimately, it's a question of how close you are to the core value, or at most it's a question of how close you are to the core value that underpins the right in question. That, I think, was the way it was put by the court in...
But anyway, so far as the researchers of all of you have gone, you haven't been able to find an example of a negative modality case
We haven't.
in the European jurisprudence.
We haven't.
My understanding of, I mean, particularly cases like Petrovich, which is quite an early case.
Yeah.
And things may have moved on. Things may be different. But my understanding of the rationale of positive modality, as in Petrovich, was that if you look at Article 8 and see its scope, each state has a margin of appreciation in how to recognise the respect for private and family life, and therefore it can do something positive to further that right to respect, which is not
Provide housing benefit.
yes, which is not required. It's not a requirement of Article 8, but it is a way of the state within the margin of appreciation showing how it wishes the Article 8 right to be respected.
Yes.
And I understand that. That's as I understood the traditional positive modality, what that meant. But have we gone away from that, or do you say we're still there?
No, we're still there.
You say that's it.
That's it.
And
That's it. And there's no case which does the other thing, which is what we've got here, which says you put up a piece of legislation which controls, for the purpose of protecting the immigration system and its effective operation, the right of a private individual to rent their property. And because that may cause them to act in some way differently and in a discriminatory manner, you are in some way within the ambit of Article 8 because it has that possible effect. Now, if you're going to go down that line, and there is no case in which Strasbourg has gone down that line, and you're well aware that there was some controversy as to whether or not they would even go as far as indirect discrimination, which they ultimately did in DH, i.e. a neutral piece of legislation which impacts more unfavourably on a particular group of people than another. But we're not in that territory, no one suggests we're in that territory. Here we're dealing with an accidental and incidental effect. But if you're going to go down that territory at all, and my primary submission is that there's no support in the Strasbourg case law for that at all, but if you're going to go down there, and you're going to try and apply some of the principles which I know you considered with great care in the Akbar case recently, if you're going to try and apply that sort of analysis to that game, it can only be on the basis of some form of link between the legislation itself and the discrimination, and some form of link that then equiparates to between the state and Article 8 and respect for the values that underpin Article 8. And so when you get into that territory, you do start by saying, in relation to Article 8, if you are there at all, well, what really is the impact here? That's why all the bits and pieces I've been going through on the evidence, and in particular that leap by the judge to a place that says homelessness, becomes really quite important. Because if what you're truly doing is, or if the true state of affairs is that you've actually got a piece of legislation which, true it is, deals with homes, but provides a perfectly coherent set of controls about that, which doesn't create homelessness in any significant number of cases or at all, which has a limited impact, query on the evidence, even if it creates a differential treatment at all. If you're there, the connections become so tenuous, even leaving aside the structural points that I've made, as to fall outside the ambit.
Well, that's one of the reasons why I asked you at a rather early stage, what happens to people who can't find a landlord who'll let to them? Are they going to be left on the streets? And you say, no, there will then be the residual obligations of the housing authorities.
Which are in part conditioned by ECHR obligations.
Absolutely. But
my submission is you don't even get there.
Would you say that of itself provides sufficient? Namely, they will be given accommodation. Everyone's agreed they have no right to a home, they have no right to settled accommodation. Would you say that in itself could give an answer?
Yes.
They will get, and it may not be very good, maybe in some unpleasant hostel in a not very pleasant part of the town, but nevertheless they will have at least accommodation.
It provides a part of the answer, is the way I put it. It provides a part of the answer because you're not dealing with homelessness on the evidence at all, unjustified link. You're dealing at most with a delay. There is real controversy, and we respectfully submit the position is that there isn't even evidence which supports the differential treatment. And on top of all of that, you have an already highly frayed and tenuous link, if link at all, between the legislation and the discrimination because of the structural points that I made. And so even if my primary case is that there's no Strasbourg case that supports...
That's your primary condition. Your primary submission is that we don't have to get into any of that.
None of that.
Because it's, put shortly, it's positive modality or nothing.
Exactly.
And it isn't positive modality.
Exactly. And
this is your alternative.
This is the alternative argument. The secondary argument is, even if you're in uncharted territory, negative modality, whatever label you choose to put on it, even if you're in that territory, it has to be still within the ambit. As I think my lord put it in your judgment in Akbar, there is still a limit under Article 8. I know the case was disposed of under Article 5 in that context, but there has to be, and correct, there has to be a limit, because otherwise it's a freestanding right to discrimination, to anti-discrimination. There has to be a limit. The question is, how do you determine that? And the only way you could think of designing a new scheme that dealt with negative modalities and all of that would be by examining the nature of the impact as demonstrated by the evidence and the causal connection between the legislation and the discrimination complained of.
I think you would say on a claimant's case, legislation of this kind can never work on a claimant's case. It can never work.
It can't.
It can't,
always
it
have that
can't,
incentive.
it can't be tweaked. It can never work. Is it time for all of us to go and have a very strong cup of black coffee?
I'm sorry it's felt like that sort of morning. But
No, sorry. How are we getting on in terms of time?
I think, well, I'm going to be done by mid-afternoon, I think.
How long do you think it would like to be, Ms. Kaufman, in your submissions?
Oh, I fear rather longer. I
I fear that too if you're saying that, but because James has laid the groundwork. But
Yes.
anyway, just can you give an estimate of how long we're going to be? 'Cause
Well, I was planning to take up all the time I had, which is until 3:30 tomorrow, I think it is. Yes, I think so. I'm afraid
that's
I'm
right.
not going to skip through the case law in quite the same way as
that's
Sir
fine.
James
Anyway,
was.
just as long as we're still on target for completing within time, that's fine. I'm sure all of you will be as short as you can be, but as long as you need to be. Thank you very much. We'll start again at 2 o'clock.
Goodbye.